ಹಲೋ, ಗುಡ್ ಮಾರ್ನಿಂಗ್ ಹೇಳಿ. ಹೇಳಿ. ಹಾ ಹಾ, ಹೌದು ಇದೆ. ಹಾ
ಎಮರ್ಜೆನ್ಸಿ ಇದೆ ಇದು. From 22nd of March. That date it has not come.
Which year matter? Which year matter?
Yeah, 22.
So what it has to come for what?
No, the history has raised the objection with regard to maintainability. The Marxi also concurred with that and gave the evidence of which time. Till today, it has not.
So who are you? You are respondent. All right. If they comply with it, it will come up. If they comply with the objections of maintainability, satisfying the registry, the matter will come up.
Argue the matter.
Let it come up, he will argue. Barutte. Oh. It's a 22 matter. Let him satisfy the office with regard to maintainability. Let it come up. It will come its own course. What is the urgency? Any interim order in your against you? But then you will go and enjoy. He has challenged the order. You go and enjoy your order. Nimge an order ilwala against. Matte yake, why do you worry? Suit for what? Suit. Illa Swami, suit for what? You have succeeded.
I have succeeded in order. I had quite an application. We stole this suit and set aside the compromise decree because it was obtained by fraud. So, registry has raised an objection with regard to this. Whether the
all right, let it come up, we'll see. Next. Let it come up, we'll see. RFAs of which year? Which? For what you want? Admission? Senior citizen. What is the age?
Age 23.
Okay, take it, we'll see what. Final hearing. For admission?
No, the second assignment is not received the notice. So I'm requesting that after
Akidira. Barli bar 2 weeks. Yesterday you moved at 1:30. Okay.
In this case, the lower court for partition, and the petition has taken this action.
Took for what? Already you have filed vacating. Lama, stay is granted by this court. You filed for vacating. Already your IA. If your IA is filed, it will come up. Have you filed IA? You file IA for vacating. You want to vacate the order. Correct, madam. If stay is granted, then you have to only file IA for vacating the interim order. File IA. Put it. Wapas put. Put it. Question, who's stopping you? All right. What do you want? ಕೊಡಿ. Give it. Review. Or the order passed by me. Especially order ಆಗ್ಬೇಕು. You have to move before the registrar because since his lordship is now no more sitting. Put it. We'll see. If it has come up, then I. All right, we'll take it. We'll take it. Wait. We'll take it up.
Adjournments, page wise, page number 8, till number 32. Page 9, from 33 to 39.
Hmm. 2017 matter. Suit for injunction. That means no case is made out by Raghunath. Stay there. Illa. 3 weeks for now. Request of learned counsel for appellant. 3 weeks time granted. Lakshmish Rao. You idira? So you can go and go vacation for 3 weeks. Yes, sir. 5. 37. Yes, what do you want? 1 week. You are for appellant. Why, sir? You have to argue 2017 matter. Madam, I told you to get listed that no adjournments to be sought in 17 earlier. Parliament tell him, we'll grant you time, but next time you have to argue. What is your name? For whom you are appearing? PM Narayan Swamy. Shiv Shankar is also on record. Proxy at request of learned counsel for the appellant, released next week. MS Vardarajan or inform ಮಾಡ್ಬೇಕು ನೀವು. Informed.
Milad, I appear for respondent number 10 and 12, Milad.
ಯಾವ್ದ್ರಲ್ಲಿ?
Serial number 37, Milad.
You have any objection?
No, Milad.
All right.
ನಾವು ಸ್ವಲ್ಪ ರೆಡಿ ಆಗಿಲ್ಲ. Refer 2 weeks.
Ready ಆಗಿ.
Please.
Serial number 26. 26. I pay for the appellant in that case. I've intimated to the respondent. I'm not unwell today.
ಯಾವುದು? Which?
26. Serial number 26, Your Lordship.
26.
Please, Your Lordship.
26. It is for orders.
No, Your Lordship. It is a hearing on IA application.
What do you want in this?
I seek for a week's adjournment. I'm not well today. I've intimated the opposite counsel also, Your Lordship.
No, there is a delay in filing.
That was there, Your Lordship. There was also interim order to grant last occasion.
Recalling order of what? Dismissal?
Please, Your Lordship, please.
You don't want to go on?
I'm not well today. That because of that only I'm seeking adjournment.
Request of learned counsel for the appellant.
The interim order is also.
Matter. What interim order when it is dismissed?
It was the respondent was directed not to persuade the matter before the executing court. There was a delay warrant issue.
Can you wait? We'll call out the matter and then grant.
Please.
Yes, call out.
Order. Number 1.
I appear for the appellants in this case, my lord. I had filed a memo on 13th December 2021 seeking to overrule the office objections, my lord, wherein the office objections was with regard to non-arraying of parties with respect to defendant number 6 to 11 and 13 to 23, my lord. Accordingly, an order was passed, my lord. However, in the order, it says 6 to 23, my lord. However, my memo is in respect to 6 to 11 and 13 to 23 months.
Where is the 13, 12? This claim no relief against 6 to 23. 6 to 11 and 13 to 23, Allah?
Yes, my lord.
Has taken risk on ready to face consequence, not arraying dependent number 6 to 23 as parties. So the order passed is dispensing notice to dependents 6 to 23.
Yes, my lord.
Now
11.
you want dependents 6 to 11 and 13 to 23 to be
Yes,
dispensed.
yes, my lord. Dispense
So
them from arraying as parties.
All right. What was your memo which you had filed earlier?
It says the non-arraying
Where is that
of
memo?
defendants.
Where is your earlier memo?
It's there, my lord. On 13th of December. May
13th of December 21.
yes, my lord.
Appellate change judgment and degree. All
The
right.
appellants.
That is the only objection?
Yes, my lord.
Learned Counsel, heard Learned Counsel Sri G.R.
Venkatesh.
Venkatesh for the appellant. He has filed a memo dated 7/9/2022. Memo reads as under. Extract the memo, Madam. Flag. It is the contention of Learned Counsel for the appellant that he had sought for dispensation of arraying the defendants 6 to 11 and 13 to 23 from arraying them as party in the present appeal. Quite memo dated 13/12/2021. However, this court, while order dated 13/12/2021, dispensed arraying of defendants 6 to 23 as parties. The counsel has filed the present memo dated 7/9/2022 to rectify the arraying of parties as an error has been committed by this court, according to him. Full stop. Placing the submission of Learned Counsel for the appellant on record and the memo dated 13/12 and 7/9/2022, it is seen the appellant has sought for dispensation of defendants 6 to 11 and 13 to 23 to be arrayed as parties in the present appeal. As he is not seeking any relief as against them. Correct?
Yes, my lord.
Submission is placed on record. At the risk of appellant, defendants number 6 to 11 and 13 to 23 are dispensed from being arrayed as parties to this appeal. What about notice to others, sir? Yenagide?
Yeah, issue objection.
From 2017 notice ಆಗಿಲ್ವ?
ಇಲ್ಲ connected matter ಅಲ್ಲಿ service ಆಗಿದೆ.
Which is that connected matter?
RFA 953 of 2017 maybe.
So that's not connected with this.
ಇಲ್ಲ, all the matters were called out together. However, because of this memo, this matter is being posted today.
So
Adukos.
all the others, the other RFAs are filed by other defendants and parties.
Other third party appeal, my lord.
So you want this to be called along with that?
Yes.
What is the RFA number?
953 of 2017.
Registry is directed to list this matter along with RFA 953 of 2017.
Yes, ma'am. Much okay.
In settlement ಆಗಿದೆಯಾ? Parties ಬಂದಿಲ್ಲ. When do you want? You are for respondent. Where is appellant Sampath Kumar? All right. His party has also not come. Okay, what is this non-compliance seventh time? All right. Learned counsel for the respondent is present in this matter. Here for respondent who? Defendant, plaintiff. Plaintiff. This appeal is filed by defendant. Correct. So whether you are plaintiff or defendant. In the first matter, you are the plaintiff. Learned counsel Sri Sarath Gowda. What is your name? Deepak. Learned counsel Sri Deepak on behalf of Sarath Gowda is present. He submits that the parties have settled the matter, filed a compromise petition which is placed on record. Since the parties could not be present before this court, he seeks short adjournment. When do you want? Release this matter on 27th September. The direction to the parties to be present before the court. Okay. They are not seeking any relief against respondent number 3. R5. R5. First case.
Order ಆಗಿದೆ but delete ಮಾಡಿಲ್ಲ
Memo is filed already. What about second matter? In the meanwhile, learned counsel for the appellants in both the matters to carry out the necessary amendment with regard to deletion of certain respondents and to comply office objections. To comply with the objections. Schedule should tally. Yes. Shall I record that they are settled? Settlement ಆಗಿದೆಯಾ? Learned counsel for the appellant submits that settlement talks are going on between the parties and they would report settlement at the next date of hearing. Release this matter after 2 weeks. In the meanwhile, learned counsel for the appellant to comply with the objections raised by the registrar. Partha Sarathi. Two weeks time granted at request of the appellant to comply. Same order. 2 weeks. Taka 2 weeks. Two weeks time granted to comply. None appears for the appellant. 2 weeks time granted. Yes, Syed Akbar. Non-compliance. What is wakalat filed by AG Shivanna for one return with office objections? 2 weeks. 2 weeks time granted at request of learned counsel for appellant. Comply. Other preemptive rather than 2 weeks time.
Serial number 8, my lord. My lord, paid the entire amount to the bank recovery suit. We paid the entire amount to the bank through OTS, my lord. It may be withdrawn. I may be permitted to withdraw, and the court fee may be refunded, my lord.
File a memo.
I'll file a memo, my lord. I'll file a memo.
Today you will file.
Today, party I have to secure the party, my lord. Day after tomorrow, my lord, I'll call him today to the office and file it. The next week, my lord, I'll file the memo to that.
All right, at request. Learned counsel for the appellant submits that he has paid the entire loan amount.
Loan amount, my lord, to the Bank of Maharashtra respondent.
Respondent bank, NC seeks leave to withdraw this appeal. Learned counsel seeks time to file a memo for seeks for refund of the court fee. Full stop. placing the submissions of learned counsel on record. This appeal is dismissed as withdrawn.
Please,
Yes.
my lord, withdraw. Yes, withdrawn.
Learned counsel, the registry is directed to refund the court fee. ಎಷ್ಟು ಬರಬೇಕು court fee ನಿಮಗೆ? Court fee ಬೇಡ?
Court fee ಬೇಕು ಸ್ವಾಮಿ.
ಮತ್ತೆ ನೀವು book ಇವಾಗ ತೆಗಿತಾ ಇದ್ದೀರಾ?
I didn't see the court fee, my lord. At 23,336, my lord.
Correct. How much has to be refunded to you?
That entire court fee may be ordered to refund.
All right. Registry to refund entire court fee as contemplated under section 66C of the Karnataka Court Fee and Suit Valuation Act, as the matter has been disposed of at the preliminary stage itself. Learned counsel to file a memo to the effect of his submission within a week's time in the registry.
Please, my lord.
File a memo.
I'll file a memo. Much obliged.
2 weeks time granted at request of counsel for the appellant to comply. Chikkappaji Gowda. Same order, 2 weeks. Usman. What is the complaints? You'll be able to do in 1 week. A week's time granted at request of the appellant. In the 1 crore valuation. Jurisdiction 1 crore. There's no representation on behalf of appellant Ashok B. Patil. That is the only objection. All right. The objection raised by the registries with regard to maintainability of the appeal before this court in view of the appeal, valuation of the appeal being more than rupees 15 lakhs, more specifically to be 1 crore as stated by the appellant in the valuation paragraph at page para 23 of the appeal memo. The same is also forthcoming in the valuation slip filed before the trial court. As subject matter value of the suit property is valued at rupees 1 crore. In view of the same, this appeal would have to be placed before the Honorable Division Bench for adjudication. Registry to list this matter before the Honorable Division Bench for adjudication. Learned for the appellant to file second set.
Malad, the proxy counsel for appellant, this mother's ceremony is there in 2 weeks time, 2 days time. Malad. Within 2 days, he will pay the cost and comply the objection.
All right, learned counsel seeks week's time. Week's time is granted at his request.
Yes, ma'am.
Do the needful.
Much obliged.
Dismiss as not pressed.
$9,000
Total sale consideration 9,000. So ಅದು ಎಲ್ಲ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ ನೀವು? 9,000 is paid by you. That has been ordered to be returned to you as alternative. ಅದ್ ಬಂದ್ ಮುಟ್ಸಿದ್ಯಾ ನಿಮ್ಗೆ? ಅದ್ ಬಂದ್ ಮುಟ್ಸಿದೀಯಾ? "28 feet by 50 feet totally must." All right. So I'll dismiss it as withdrawn. Memo ಹಾಕ್ಬಿಡಿ ಒಂದು. ಹಾ. ನಾಳೆ ದಿನ ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದ್ದಾರೇನಾ? Learned counsel. All learned counsel Sri Gangadhar Aital is present before the court. He submits that the appeal may be dismissed as withdrawn. His memo is placed on record, so also his submission. Appeal is dismissed as withdrawn. Yes, sir. Murugesh. In memo for posting. Memo for posting. You are practicing in Bangalore?
Last time came to report for objection complaint.
ಲೇಟಾಗಿ ಬಂದ್ರೇನು? ಎಲ್ಲಿಂದ ಬರ್ಬೇಕು ನೀವು? ಎಲ್ಲಿಂದ ಬರ್ತೀರಾ ಹೇಳಿ? ಎಲ್ಲಿಂದ ಬರ್ತೀರಾ ಕೇಳಿ. ಅವ್ರು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ ಅಂತ. 10:30 ಯಾಕೆ ಬರ್ಲಿಲ್ಲ? ಲೇಟ್ ಆಗೈತೆ. ಆಲ್ ರೈಟ್, ತಗೊಳ್ಳಿ. ಆಲ್ ರೈಟ್ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಟ್ ವಿಲ್ ಕಮ್.
Number 15, Mukesh Vicharati.
ಮೈಕ್ ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳಿ, ನಾನು ಕೇಳಿಸ್ತಾ ಇಲ್ಲ. ಕೆಳಗ್ ಮಾಡಿ, ಅದು ಕೆಳಗ್ ಮಾಡಿ. ಹಾ. Not filed application, condemnation of delay. You want to file? ಒಂದು ವಾರ ಬೇಕಾ? Day after tomorrow. A week's time granted. Learned counsel to file, to do the needful. ಮಾಡಿ, day after tomorrow ಮಾಡಿ. What is the value, Nagendra? ಅದೇ DBOB ಅಲ್ಲೇ ಕಳಿಸೋಣ. Learned counsel for the appellant is present before the court. Submits that as per the valuation slip produced along with the appeal memo, the subject matter of the suit is valued for the amount of rupees 1,43,75,000. The appellant herein is claiming 1/4 share, which would be 35,93,750. Therefore, in view of the said admitted position, this appeal would have to be placed before the Honorable Division Bench for consideration. Accordingly, it is placed. Registry is directed to place this matter before the Honorable Division Bench. Learned counsel for the appellant to file.
Sarah Bibi.
2 weeks granted at the request of appellant. 2 weeks granted. What is?
Only one officer.
So what is the suit? You're claiming how much share? So what will be the value of that? No, if it is more than 15 lakhs, it will not come before single judge. ಎಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ ನೀವು ಸೇಲ್ ಡೀಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀರಾ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಲ್ಲ ಸೊ ನಾವು ಆಲ್ರೆಡಿ ಬರ್ಕೊಳ್ಳಿ ಹರ್ಡ್ ಲರ್ನಡ್ ಕೌನ್ಸಿಲ್ ವಿಶ್ವನಾಥ್ ಶೆಟ್ಟಿನ ತ್ರಿಮೂರ್ತಿ ಆಲ್ರೆಡಿ serial number Trimurti is filed a memo dated 3/7/21 wherein he has stated that the subject matter of the suit is valued at rupees 2,42,900 and he has produced exhibit D40 for the verification of the same. Full stop. And the present appeal is filed by, what is your share? One present appeal. In the present appeal, 1/7 share is claimed by the appellants. Therefore, it would not exceed 15 lakhs. Hence, the objections raised by the registry is overruled. Already caveat is there, is it? All right. List this for admission. Admission. List for admission. 4 weeks time. 2 weeks time. Why? What about the cost? 500 rupees cost. Kottidira? Verify. We'll increase it by another 500. Yes? 500 increase ಮಾಡಬಹುದಾ? ಅಷ್ಟೇ ಇರಬೇಕು. 2 weeks time granted at request of client counsel for appellant to comply. You are still here before this court. You should settle this matter. What is this? How many times it has come? No, this is that matter where he is the subsequent purchaser in the FTP proceedings, deciding which portion he has to take. He is dictating. Now, you did not find out from your client.
Yes, sir, I found out. 4 items have been sold out of 7. And I'm told the purchasers have kept this matter, whatever share I don't do the but that portion is untold is depleted. Some items have been related to half share, some items have been related.
What happened to the service of notice to?
Service of notice to the learned counsel.
Who is the senior counsel? He is a designated senior. All right, you are also on record. What's your name? Prashant? All right, you go on with the matter. Don't worry about it. Let him go. It is his prerogative. He wants to go play cricket, hockey, football. It is his choice. No problem. You can argue the matter. For what? Who are you? Who is he? You purchase from him. ಆಯ್ತಲ್ಲ ನಿಮ್ದು ಕೆಲಸ ಮುಗೀತು. You have any stake? No, you're a family member. Oh, you're the LRs of his brother. All right, now you have already sold it. What is there to hear you? You have stepped into issues.
The other 3 properties are 4 properties. My vendor is there. He's having a more share in that one, and it is stated. I requested my lords on the other day also, that he can take, he's ready to part with that of the share which is, I mean, this part, in lieu of the share which is, he has one more share. The other property which is not more than this property not to there, or he can bring that property, that's not my, so he has got no objections for posting.
So he has sold only one property or all property? So others he will still have share.
That he has also, that's what I might request is, because he is parting with that of the property where the other shares are there. In view of the property which is soon to be created, 1/4 of the share is there.
All right, Mr. Vijay, as I understand, your grievance is that he is trying to dictate which portion which he has already taken and asking you to take remaining portion. That is your grievance.
My property, you have other items, both shares are other items. I have purchased the property, understanding the fact that it is purchased in violation of the order and also doing a pretension.
All right.
He said, just give me a loan.
All right. You seriously want to contend that, or you are interested in trying to take a better portion of the property which? What is the extent? 36. 36 guntas. What is the value of this? Okay. This is in Belandur, is it? Whether you are going by rowing the boat and swimming inside the bedroom. Sir, there's some video surfaced where the piano is also floating. Piano is floating and the Picasso is also floating. Adena? Then that is very priceless property, sir. 1 acre, it's definitely more than not 15. It is, I think, more than that.
I have people say I'm close. Requesting my lord that the other person they equally are more worth than that property. We ask to his share.
Then you pay him that amount. Correct. So once you give that other portion, you pay the difference amount of this.
The other three-fourths will be with me, and the other shares, I have half of the property. Where he has got only 1/4, three-fourths, the other will 1/4, so the property, he has got more. Yes, and we have the other property is free from all encumbrance. There is nothing like that.
Others have also purchased and they are
watching from a distance, now you watching from the country. 1/4 of the property in case it is to be sold, one of the property has to be sold by both.
You want a portion of this property of this 36 guntas as a share? How much you get in that?
I would think about over
9 guntas.
That is clearly set up. Even today,
all right, that's okay. So you have to get 9 guntas here. So what is the value of 9 guntas?
9 guntas should be about. There are certain things around each other. I spoke for the minority last. They have other intentions, but they thought, I would stop to whatever. They don't have, they don't have a clear intention or
He's intending to settle the matter. You have purchased in the other portion also. Then say that you cannot say that he has to say. You have purchased only this 36 guntas. Item number 4, 36 guntas from him. So you can't say for him. That is, he has to say. Yes. Oh, no. I'm not going to grant you time, sir. You can go internationally, you can do whatever you want. This is coming for the third or fourth time before me. No. Whether are you willing to settle or you want this to be heard? Otherwise, I will hear him. No, time will be granted if you are willing to settle. Otherwise, no point. I will hear him. You tell tomorrow. Speak to your senior. No, you speak to your senior whether you are willing to settle or not settle. I will hear them. Then your senior can come and argue on 16th. If you are not settling and you are only dragging on the matter. Where is he? In some. Australia is not communicable. Yes, you tell listed day after tomorrow, you find out, speak to him and your parties, whether you are willing to settle the matter. If you are not willing to settle, then I'll hear the arguments. Worker Learned Counsel for the appellant is present before the court, so also Learned Counsel Sri Shivarudra for R2, along with Learned Counsel Sri Prashant appearing on behalf of R1. Learned Counsel for R1 submits that his senior is not in the country, hence he seeks some time. Relist this matter on 19th. He'll be back. All right, relist on 19th with a positive direction to all the parties to either furnish a proposal for settlement or to proceed with the arguments on the matter. On that day, don't again come and stand in the same footing of giving, taking, that you do it outside the court. I think you can say what is the other portion you want and then agree with him. He will either you seek for extra amount of the other portion if it is not valuable. Intention illa. Yeah, because you have already sold, so you are not bothered. Already you get ready on 19th. Yeah, if this court comes to a conclusion that the sale is not valid because it is hit by dependents, then that will go. So he's going to now go after you. So you beware. He's going to ask you damages for swimming in the Belandur. Anjanatha, DB, value 15. These are values. No representation on behalf of appellant. Release this matter after 2 weeks. No representation on behalf of appellant. Released after 2 weeks for compliance. ಯಾರು? What about R2 to 7? They were ex parte. They were ex parte.
Yes, sir.
Whether they are ex parte, you don't know. Or to Yusuf Baba. That is different, sir. Whether they participated in the proceedings by filing wakalat. 2 to 5 placed ex parte. 2 or 2 to 5 in your appeal. Defendants 2 to 5 or 2 to 5, same 2 to 4, 5 are the defendants who are placed ex parte. What about 7, 6 and 7? Either Allah, 6 and 7. Maybe they will come before this court and they may appear. You want dispensation
I think it.
for 6 and 7?
I had an order not within. We are trying to relate it to
So the specific performance suit filed by you is dismissed. What about how much? How much is paid? 10 lakhs. By way of
some by cash, some by.
you had an interim order in the suit till the judgment. Till the judgment, not to alienate. Where is that? What are you seeking now? EI.
So I paid 61 of my academic I have paid. Paid 61. Both my.
Yes, sir. No, you are seeking interim order from whom? R1, your R1. So you don't alienate. No, we don't alienate. Next week, anything in it. Not to alienate, sir, that's all. Because he had the order. Should have filed a memo. Learned counsel for the appellant Sri Yesu Baba R. Mishra is present before the court. Learned counsel Sri Aruna GS for KBT respondent is present. Learned counsel for the appellant submits that the defendants 2 to 5 who are arrayed as respondents 2 to 5 before this court were placed ex parte and did not contest the matter before the trial court. Full stop. They have to be dispensed under which provision? Not either. And we have provisions under Order 41 rule. One, Order 40. Order 41 Rule 14. In view of Order 41 Rule 14, notice to respondent defendants 2 to 5 is dispensed in view of them having been placed ex parte before the trial court. Full stop. Learned counsel seeks dispensation of notice to respondents number 6 and 7 who, though filed, wakalat but did not contest the matter before the trial court. Learned counsel is at liberty to file the said application. Relist this matter after 2 weeks for the same. Stop. In the meanwhile, heard learned counsel for the appellant as well as respondents. Orders on IA number 1 of 21. 1 of 21. Stop. This application is filed. You have not filed objections. This application is filed by the appellant under Order 39 Rule 1 and 2 read with Section 151 CPC, seeking for an order of temporary injunction as against respondent number 1. You file a memo that's only against R1. So you have not said so in your IA. You have said against respondents. You have not specified. You can file. In the meanwhile, we'll grant. Restraining the respondent number 1 from alienating or creating third-party rights with respect to the suitural properties till disposal of the above, till disposal of the appeal. Full stop. It is the contention of learned counsel for the appellant that this appeal is preferred against the judgment and decree passed by the trial court dismissing the suit of the appellant which is filed for enforcement of a specific performance of contract of agreement of sale dated 18/3/2004. To stop. It is the contention of the appellant that he has paid the entire sale consideration amount of rupees 10,50,000, correct? And there is no amount pending to be paid as the full sale consideration amount is paid by the appellant plaintiff to the respondent defendant, respondent number 1, defendant number 1. Full stop. He further contends that during the pendency of the suit, the appellant plaintiff had enjoyed the benefit of an interim order of injunction till the conclusion of trial and the passing of the impugned judgment and decree, which is stated in the affidavit at para 5 annexed to the application for interim order. Full stop. The said fact is not disputed by the learned counsel appearing for respondent number 1. Full stop. While considering an application under Order 39 Rule 1 and 2, 3 necessary ingredients are required to be taken note of, namely prima facie case, balance of convenience, and irreparable injury to the aggrieved party. In the present case on hand, admittedly, the suit came to be filed by the appellant for seeking to enforce the specific performance of a contract, and it is his contention that he has paid the entire sale consideration amount. In view of the fact that he had enjoyed the interim order before the trial court till the conclusion of trial, he is entitled to the benefit of the interim order till at least next date of hearing. Full stop. A prima facie case is made out by the appellant for grant of interim order. The next point for consideration would be balance of convenience, and thereafter the hardship that would be caused to the aggrieved party. Both these 2 points would automatically tilt in favor of the appellant plaintiff in view of having paid the entire sale consideration amount as alleged in the plaint, so also in the appeal memo. Full stop. And in view of the fact that he had the benefit of interim order till the conclusion of trial, I do not find any legal impediment in allowing the application and granting him an interim order in favor of the appellant plaintiff, restraining. Therefore, I pass the following order. Restraining. Therefore, there shall be an interim order of temporary injunction restraining the respondent number 1 from alienating or creating third-party rights in respect to suit schedule. Yesterday, properties. Suit schedule item number 2. Suit schedule item number 2 property as mentioned in the application. Till next date of hearing. That is 27 kuntas, 2 acres. 27 kuntas out of 2 acres, correct? Item number 2 of the suit schedule property described in the application. Huh? No, you have made on. Item number 2 and 3 made. Item number 2 and 3 will be flagged in orange. Till next date of hearing. IA number 1 is accordingly disposed of. You can file that memo. You're filing now. All right. Memo seeking dispensation. No, what is this? Only, all right. This is restricting only to R1. No, the other memo you have to file 6 and 7. All right. No, you are seeking dispensation or you want 6? No, if needful is done, registry to issue notice to 6 and 7. 2 weeks. If needful is done in 2 weeks. Gangadhar.
And as far as the second objection, the amount for mistake in the
You want to withdraw IA 1 of 22?
Yeah,
All right. What is this IA now? 1 of 22 was filed for what? So you want to withdraw that?
Yeah, the schedule was wrong.
All right. Learned counsel for the appellant. Shri Gangadhar is present before the court. Learned counsel Shri Nandish Gowda is also present. Full stop. Learned counsel for the appellant has filed a memo seeking to withdraw IA number 1 of 22 as not pressed. Same is placed on record, so also is sufficient. IA 1 of 22 is dismissed as not pressed.
IA 2 of 22 was filed on 26/7/2022.
Learned counsel for the appellant submits that he has filed IA number 2 of 22. Copy Kotra. Copy of the same is furnished to the learned counsel for respondent. Registry to verify and put up the IA. So what is the connection? They are connected. So you're one of the defendant. So RFA 692 is filed by you. Who are you? All right. Who has filed 624?
692 filed by client.
624?
624 one of different 1 to 7.
All right. Registry is directed to list this appeal along with RFA 624 or registry to list RFA 624 and 692 along with this appeal. You have some objections also. In the meanwhile, learned counsel for the appellant to comply the objections raised by registry. Yes. Yes, sir.
I pay for the appellant in this case.
that my vendor has not paid in consideration.
So this is a case you are seeking for some time.
Please, in the morning, due to my ill health, that is what I've intimated the council. I'm
You
council.
sought for time in the morning. We were waiting for you. He says he is not well. We'll have it some other day. Any urgency?
At the ending of the past, that is something that I want to fix.
No, but this appeal is dismissed.
It was dismissed.
In that order itself, your project has voted till next date at the night. And then we will fix it.
Please, please.
You'll have to argue, sir, before your appeal is restored. Where is the question of interim order?
I'll argue in the next video. So my ill health.
For the appellant submits that he is not keeping good health today. When do you want?
Any date in the next week, Your Lord, any date.
The counsel for the respondent is also present before the court. When do you want? Release this matter on 20th.
Please, Your Lord.
The undertaking of the learned counsel for the respondent. Undertaking is in them though. Court order. The order dated 1/9/2022 stands continued till next date of hearing.
Much of-
The tendency of the appeal, tendency of the property has been sold to one sheet who has purchased the property to respond to 102 OS was the type of OS of benefit. I have filed an application to Interim. He had sent us a reminder. Letter of the premises has to be paid to him. There was a settlement between the appellants and Sheriff. We have paid the rent regularly. 20
So you're the tenant.
I am the tenant.
There is a tenant's appeal
The tenants.
on an ejectment suit. You're the plaintiff.
But only one sentence. On 19/4/22 in the order, we were directed to provide memo of calculation and also pay the arrears of rent as per our calculation. We were 4 weeks time was due. We have paid a portion of the arrears of rent. Time pay the balance amount because there was severe loss of the COVID time. So my petition
You're an agricultural land or about building.
the open yard may not. Here, Balaswadi. And this property has already been acquired by the BD. Acquisition proceedings is also over. The different aspect may not be the two landlords have said. I am paying the rent. I can be given 1 week time. Monday I will pay the balance amount to her. The 3 other ideas, one for increase, one for amendment, and another application. If they return the after a deposit. A deposit they put on them.
Yes.
What has happened in this case? Yes, I tried to wait. And in 2019, the order can be passed. Directly to vacate the position.
Suit is of 2012.
447, 448 RFP.
Ah.
And the common landlord of common. Tenants are occupied. 3,000 for the rent was. That they will not deposit the money. What has happened? They pleaded fraud of selling the property of mine in the PB. I have filed a criminal case. Police have investigated the case and charged both the broker was in these cases. Explain Miller that I am not subject of a right. Submitted to Interim was said that the progress of all the things are there. Total master of it. And paying saying that I am for the property, I am the owner of the property. There is another cost in the sample code, I think the plan mine says that the not be paid. The limit times comes up from the plan times the other one. If I to one small mistake in capital, the parking lot, you were directed to pay because the meeting default. The Interim order until next day of their payments. So that then subject to because of the rate. That's what let's see, five, value to last.
Four 47, 448. If the arrears of rent is not deposited by 25/5, interim order granted by this court stands vacated. And then thereafter, interim order granted is extended till next date of hearing. That is what you want to bring. So you are not paid. What are the total arrears? All right.
I will deposit this money on Monday because due to COVID we had no business. And due to the rain, all my wooden articles are. My loan in a cooperative society has been sanctioned yesterday. They are going to release it on Thursday. Friday they may get the ED and the abandoned portion on Monday I will deposit.
Both the cases.
Both the cases. The matter will be called on Tuesday. The two IAs will be heard on Tuesday. Matter can be heard on that day. Each case is liable to pay 18 lakhs. So that after okay, one submission memo. They have filed a memo of calculation, we have filed a memo. The adjudication can be made on. That's all.
Have you filed memo of calculation? You walk it there.
18 lakhs,
18 lakhs. In each case. So almost 20 lakhs. 18 plus 18, 36 lakhs. Yes, from when he has not paid? From when he has not paid?
2017 onwards. And now he says, come, COVID. I also similar situation. I have to survive. He may have to survive. COVID, he could not have to do that. I have to survive.
Now, on what basis this arrears of rent not deposited on the order 19 for all matter? No. What is the basis of this court passing an order earlier that arrears of rent if not deposited? Is it anything is specified? What is the arrears of rent?
We have to find the calculation.
What is your calculation? He is not admitting that. But as per the order, 15,000 per month is the. What is that? Yes. Where is that order of trial court? How much does it say is the rent?
15,000 per month.
So that 15,000 rupees from per month from when? From the date of suit. Date of suit is when? 2012. 12/7/2012. What is the calculation? 7 ವರ್ಷ ಆಯ್ತಲ್ಲ.
I'm stating one.
10 years. Yes, Mr. Kamath. Even if we go by the trial court judgment, 18 lakhs will come to one case. Of which court? 18-1.
Current counsel for the respondent to serve copy of adjournment C on the other counsel for the interim order if any is extended to next interim. Both the parties to file memo of calculation regarding the amount due to the same. The FIR to request the amount due as per terms of the memo calculation filed with the appellant in next meeting. My submission is by this memo. I have filed memo of calculation on 25th January 2022. According to in the RSA 447 memo of at the rate of 10,000 rupees for 94 months, 9,40,000 rupees is the rate.
How you have calculated 10,000?
The original rent of 10,000 rupees.
No, you are calculating by your own whims and fancies. No, that is not the order of the trial court. That we'll see.
My submission is this way, according to both the directed by the law firm. The order is that appellant deposit the as per the memo of calculation filed by the appellant by next year. Now, according to me, my lord, 1,40,000 rupees is 447, and 2,10,000
at the rate of 10,000.
At the rate of 10,000.
So,
Because I am paying rent. He has come and he has spread over the property and he has told.
where have you paid?
He has agreed, he has admitted the proposed respondent has admitted we have filed an executive.
That is your headache between you and him.
No, my submission is only.
That you can recover from him and give it to him.
No, my submission is only this.
You are disputing you're a tenant. Are you disputing you're a tenant of the plaintiff?
Okay, now there is a dispute of ownership between two persons.
No, are you disputing you're a tenant of plaintiff? Simple question.
As on today, my lord, as on today, I am the tenant of Sheriff.
In the trial court, when plaintiff filed the suit.
The order is now, the judgment is now in view of this letter filing the suit. Now, in this order, for this honorable court, identification requires to be made. Insofar as to whom I have to pay the rent, and whether this order of the judgment of the trial court, so far as the same by the Lalita in favor of Sheriff is valid or not, requires to be adjudicated with a limited scope, my lord, because any sale deed is valid till it is set aside by a competent civil. Criminal case has no reference to civil.
So during the pendency of the trial court proceedings, plaintiff has sold it to the proposed pleading.
And that has not been disclosed before the trial court because for two reasons. One, the property has been acquired by the BDA. Acquisition proceedings is pending. Alkavati project is acquired the property. So how much ever rent he wants to receive, he wants to receive. My humble submission, since there are two memo of calculation, the lordship may adjudicate the matter. Until
Yes, sir.
Now my limit friend has not because of the entire money. Now it's 6 times, even further because of money. All later on the time, I find the difference spectrum as for the direct report, we cannot recover. The primary honor, they also the other. It says that they can't have Online, 579.
Have you filed execution, sir?
I don't
Yo.
know.
No, have you filed execution? That is state.
There's an article, 22/9/21, you know, the FIR ಮತ್ತೆ charge sheet ಆಮೇಲೆ five minutes. There's a some charge sheet.
Charge sheeted the tenant on for what? The so-called your purchaser from who? Your purchaser from whom? You? No, from the purchaser from you.
Claim to have purchased.
Claim to have alleged person.
Yes. ಅವ್ರ ಮೇಲೆ charge sheet file ಮಾಡಿದ್ರೆ the charge sheet is sub-registrar ಹೇಳ್ತಾರೆ. Chain ಆಗಿ ಅದನ್ನು copy ಕೊಡಿ.
So that's a fraudulent document and so that criminal case is going on.
Suppose ಅದಕ್ಕೆ ಇದರಲ್ಲಿ ಚೀಟಿ ಓದಿಗೆ ಎಲ್ಲ ಬರೆದಿದ್ದಾರೆ. Charge sheet payment. ನೀವು ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ರೆ they are not entitled to prosecute the case in the law. Now will not get into the name the order came to the pass. And it doesn't I also
Tara?
I always not always says to depend upon.
Yes.
Relationship or landlord connect between cannot allow the to deposit the due amount in a right damages for due and occupation. Unless it is so, having made such a payment in a lawful and bona fide manner. Oh, the question of bona fide is a question of fact to be determined in every case with respect to its facts, but it cannot be laid down as a general proposition that the mere denial of the title of the native or the license of the landlord is done in respect to the difference of the two, the present nature would not enjoy the property during the tendency of the two without depositing the rent and the rents due. Then now we will continue to depart. The question of other things does not arise. As I said, the order is very clear. Taking time, there is no end for it.
Yes.
My only submission. I was sought for extension of my agreement spending. Now I am seeking only 1 week time in view of that application for extension of my deposit balance on Monday. Tuesday, if I don't deposit,
That's all. Yes. Heard Learned Counsel Sri Ravindranath Kamath on behalf of appellant. Is Hanumantarayappa also on record?
No, Ravishankar.
So Hanumantarayappa is not there.
He gave endorsement to me before I came. Now I am Ravishankar.
Record. So your name has to be deleted? Your whose name has to be added? HM. Learned Counsel Sri HM Ravishankar has obtained NOC Wakalat from Hanumantarayappa K. Registry to show the name of Learned Counsel HM Ravishankar as counsel for appellant in the cost list and delete the name of Learned Counsel Hanumantarayappa and so also the name of Learned Counsel N. Ravindranath Kamath, full stop. In view of the fact that Learned Counsel Ravindranath Kamath is designated as a senior counsel, full stop. Learned Counsel the senior counsel Sri M.T. Nanaya is present on behalf of M. Ramakrishna for R1 and R2 for the respondent number and Learned Counsel Siddhamalappa. P.M. Gopi is present for the pleading respondent number 3. Full stop. By order dated 19/4/2022, this court granted time till 25/5/2022 to the appellant tenant to deposit the arrears of rent, failing which the interim order granted would stand vacated. Full stop. It is submitted by learned counsel for the appellant that due to COVID-19 global pandemic, was unable to muster the amount of rent to pay and deposit before this court. He submits that he would deposit the arrears of rent as per his memo of calculation by 19th September 2022. He seeks the short accommodation of 4 days. Full stop. Learned senior counsel Sri M.T. Nanaya vehemently opposes this adjournment as tactics to drag on and prolong the matter without payment of arrears of the rent. Full stop. And the memo of calculations is disputed by learned counsel appearing, learned senior counsel for the respondent 1 and 2. Admittedly, both the parties have filed their respective memo of calculations, which has to be adverted to by this court. In view of the short adjournment that is being sought by learned counsel for the senior counsel for the appellate, I deem it appropriate to grant a final chance to the appellant to show his bona fides by depositing the admitted rent as per his memo of calculation to be deposited on or before 19th September 2022, failing which it is made clear the interim order stands automatically vacated and the respondent plaintiff would be at liberty to enforce the execution proceedings. It is also made clear that on the next date of hearing, the matter is listed, the memo of calculations of both the parties would be taken up for consideration. The matter will come up on 20th because 19th is the last date for him. You can execute it on 20th or I'll also come before this court. Relist this matter on 20th. LRs of deceased R2, is it?
I'm for respondent number 1 to 4, my lord.
You're appearing for the LRs.
I'll appear for LRs. I filed wakalat, my lord.
You filed?
Filed.
No, have you filed? I'm not clear. Are you clear? You're appearing for respondents 1 to 4 you submitted.
1 to 4. My lord, I have filed one more cross appeal in this case, my lord.
No. Are you appearing for the LRs of R2?
Yes, my lord. I'll appear for LRS of the appellant number 2. Yes, my lord. Respondent number 2.
A to C.
My lord.
What is your name? Amritesh?
Amshit Hegde.
Amshit.
Yes.
Learned counsel Sri Amshit Hegde, HS, is present before the court and he submits that he is appearing. He represents respondents 1 to 4. He also submits that he would undertake to appear on behalf of respondents R2, A to C. Full stop. Registry is directed to show his name as counsel for R2, A to C. Will allow these applications.
Yes, ma'am.
IA number 1, 2, and 3. Learned counsel for the appellant has filed 3 applications, IA number 1, 2, and 3 of 2021. Seeking for condoning the delay of 300 days in filing the LR application, to set aside abatement and to bring the legal representatives of deceased R2 on record. I have perused the affidavit annexed to the application. Full stop. the reasons assigned and the cause shown therein in the affidavit appear to be bona fide, genuine, satisfactory, the same is acceptable. Hence it is accepted. Full stop. Learned counsel for the respondent, LRs of respondent 2 is also present before the court, and he also does not have any objections to the said application being allowed. Accordingly, I deem it appropriate to allow the application as there is no legal impediment to allow the application. Full stop. Therefore, IA number 1 is allowed, condoning the delay of 300 days in filing the application. IA number 2 is allowed, setting aside the abatement, if any. IA number 3 is allowed to, when the appellant is directed to bring on record the LRs of R2 as R2A to C on record. Full stop. Then counsel for the appellant to carry out the necessary amendment in the appeal memo and also file the amended appeal memo by serving a copy of the same to the counsel for respondents. This what else?
Kindly direct the office to list the cross appeal along with this appeal.
What is the number?
That is cross appeal number 1 is given. 1 of 2020.
1 of 22.
Yes, ma'am.
Registry is directed to list cross appeal 1 of 22 along with this appeal.
Right.
29, Ramesh.
Yes, Mr. Ramesh. First week, ನಿಮಗೋಸ್ಕರ ಬರಬೇಕಾಗಿತ್ತೆ ಮಿಸ್ಟರ್ ದಿನೇಶ್. ರಜೆ ಇದೆ. You are settling the matter or something? In his favor. In injunction suit. Relation or strangers?
He claims 242A, but 240, he claims 242A. This is the dispute now.
Suit is decreed.
Not officially the admission of the.
So, according to you, he is claiming 240? 240. You say that there is no such site.
No such site.
Ah.
Vendor has already been eliminated. No site. But he only claims on a CPA executed by vendor's radar. That is original matter.
Sale deed ಇದೆಯಲ್ಲ.
Where in that CPA can exist any site number or property number.
So you are claiming title by?
By virtue of the sale executed by the plaintiff's
Vendor.
GP owners, other products, who was alienated.
So what is your site number? He is claiming 240. And how are you affected?
See, there is no such man mind. He is asking about the site.
Right? If his site is not there, then he cannot claim on your site. And did you file counter claim?
What's here? He has specifically admitted in the cross examination that the documents, that is the same deeds, in respect of the mindset, he has created.
All. Barkali. Learned Counsel Sri B. Ramesh and Learned Counsel Sri N. Dinesh Rao are present before the court. Both the Learned Counsel seek adjournment. Oh, the Learned Counsel for the appellant seeks some time. Hence, release this matter on 11th, or we'll post it in the second week of October, third week. First week will be first. Alva. Release this matter on the third week of October. Huh? 12th is okay. Released on 12th. Interim order ಇದೆಯಲ್ಲ ಅವ್ರದ್ದು. But you're given an undertaking. The interim order shall stand extended till next. The interim order of undertaking shall stand extended till next date.
It's a small matter.
Records of
Records also.
No, but you will be evidence is adduced. Correct. No, but you will be relying on the cross-examination evidence and other things. We'll see next time when it comes if it is not required. It will come in the same stage. Hearing INA barbeku. Because your IA is not disposed of yet. He is only given a voluntary undertaking with his great magnanimity. Yes, Sukumaran.
My lord, this is a partition suit, my lord.
Notice.
Yes, ma'am.
Issue notice to the respondents.
Yes.
Prashant. Same. Notice. Delay there. A suit for specific performance. You are the purchaser or owner. Suit is dismissed. Refunding. Refund. Yes, sir. So you want the property. What is the total sale consideration? Entire amount you paid. So now they are planning to alienate. But notice hogbekalla. Correct, sir. But no, but any order that the first delay has to be considered. Otherwise, on that ground it will go. But issue emergency notice to respondents. Our execution prashna ಏನು ಬರೋದಿಲ್ಲ. All right, we ಎಲ್ಲಿ ಹೋಗ್ಬೇಕು notice ಎಲ್ಲಿ ಬೆಂಗಳೂರು ಏನು? We'll relist after 2 weeks. Relist this matter immediately after service of notice or within 2 weeks from today. You play the process and see that it is served. And yes, sir. Figure, huh? Yes, sir.
My possession up to the various only patent. In order to establish title, I produced the registered CAD.
This is a suit for
injunction.
the injunction. Suit is filed by you.
As owner in possession.
So it is dismissed on the ground.
On the grounds, the lawyer judge actually concluded on the basis of the document of the defendant, saying that there is the defendant says that I have a power of attorney. My principal who has executed power of attorney is the nature exposed. The principal's power of attorney is court into convention based, but the principal in another criminal case makes a statement that I have not told this is the power of attorney. I executed the person who sold the property. Now that apart from that, the very same principle executes it in your confirmation.
In your favor.
In my favor. Confirming title.
A title. Then where is the dispute?
There cannot be a dispute.
When
Therefore, the government judge has added so far.
So the principal has validated and also by
ratification is validated. Therefore, the contention of the trial court and the contention.
now one is ratification, then he has also done a confirmation deed. Okay. So which is the property beyond that shed or
Beyond the shed, photograph and the shed that is put up there. These photographs by my property, which is vacant. In page 5 note, there is one more photograph as to how the shed is. Apartments of Rama on the bigger size of the property. But this shows the vacant land, no construction. But I only said, I cannot put up construction. Then take some order by this court or maintain.
Now your property is somewhere beyond that or this one? This one. Oh, so that's an open area. Open area.
There was construction, I would have filed an affidavit saying that.
So, but there is no barricadation. I mean, it's not barricaded. It's not compounded and fenced. How do you measure this, and what is the measurement?
The measurement of the property, which I have shown, is east to west 86.9 plus 85, north to south 106 plus 91, 8 houses. Page 33.
8,466. That is open area.
Yes, open.
So you want an order of status quo of this? Because your application is to restrain respondent. But, ಅಯ್ಯಪ್ಪ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದೆ ಅವರಿಗೆ. Learned Counsel Shri B.B. Shivkumar for the appellant. ಮಂಜೇಗೌಡ ಇದಾರ ನಿಮ್ ಜೊತೆ ಇದಾರ ಅವರು ಕೌನ್ಸಿಲ್ ಮಂಜೇಗೌಡ? Learned Counsel for the appellant has filed a memo dated 5/9/2022 along with six photographs and a CD. Stop. These photographs are produced to show the nature and status of the scheduled property, suit scheduled property. Stop. On perusal of these photographs, subject to dispute or objection raised by the other side, it is seen that it's a vacant property and there is no construction put up in the said scheduled property. Full stop. Learned Counsel has filed an application under Order 39 Rule 1 and 2 to restrain the respondent from interfering or dispossessing the appellant's unlawful and peaceful settled possession of the suit scheduled property. Though the notice to respondent is served, there is no representation either by himself or through a counsel. Full stop. In the pending consideration of IA number 1 of 2022, I deem it appropriate in the interest of justice that an order of status quo be granted with regard to the suit application scheduled property measuring to an extent of 8466 square feet as per the schedule mentioned in IA number 1 of 2022, that both parties shall maintain status quo with regard to nature and status of the suit scheduled property. So according to you, you are in possession. Next date appear. The release after 2 weeks. We'll have it after 2 weeks.
My lord, this is for serial number 33.
Yes.
My lord, the serial number 33, the party has taken a NOC and no objection on 30.
You have filed. Your father appellant. Oh. Mr. Sukumaran, he has filed. So we'll delete your name.
Yes, my lord. That is what my name is now. That is okay.
All. What is your name, sir? Sampath Kumar. KV, na? AV.
Yes.
Learned Counsel Sri Sampath Kumar AV, who is present before the court, physically submits that he has filed NOC wakalat from the previous counsel on behalf of appellant. Registry to show his name in the cost list as counsel for appellant and delete the name of learned counsel Sri Sukumaran G and AM Venkatesha.
Yes, my lord.
From the cost list.
Grateful, my lord. Obliged.
Yes, what do you want? You want to withdraw? In money suit? Money suit?
NOC.
You are the defendant or so you paid the amount? All. Mahalakshmi is the respondent. The respondent is now age 22 years. Major. One minute. So this is between father and son. What was this son? What was this dependent father to pay to the son? What amount is this? The suit was filed by the mother on behalf of the minor child, which was decreed. Why they have separated? Mother and father have separated. Or divorced or? How have you filed RFA? How your RFA is maintainable? Madam, where is the order sheet? No objection raised by the registry. How RFA is maintainable? The original suit filed before the family court at Mysore. Huh? Objection raised. Maintainability of the appeal, the first question. And how I can pass an order. Have you paid the amount? Have you paid the amount? You're appearing for the father, right? So you paid the amount for your son. Barcode. This appeal is preferred by the defendant against the impugned judgment and decree passed by the Second Additional Principal Judge Family Court at Mysore in OS number 86 of 2018, wherein the trial court, the family court decreed the suit of the plaintiff, respondent plaintiff in part, and directed the appellant defendant to pay education expenses of 1,88,090 rupees to the plaintiff and also directed to pay 1,73,090 per year for a period of 3 years towards the educational expenses of the minor child. You want to continue to pay? Ask your client. Paid. Why you want to come to court to pay to your son? Don't waste your time here. Go and spend some time with your son and pay the money, sir. Why you want to come to the court for these months? The same is challenged before this court by the defendant father. There is no divorce between you and your wife by the father. The registry has raised an objection with regard to maintainability of the appeal in view of section 19, Family Courts Act. 19 of the Family Courts Act. However, be that as it may, Learned Counsel for the appellant has filed a memo seeking withdrawal of this appeal on the ground that he has paid the entire amount as ordered by the family court. Without considering the matter on merits with regard to its maintainability, this appeal is dismissed as having been withdrawn by the appellant. Memo and the submission of the appellant is placed on record. You have signed this memo? You have signed this memo? Along the appellant, Mr. Ravindra Narayan, L. Ravindra Narayan is also present before the court and concurs his signature on the, affirms his signature on the memo filed by the counsel for the appellant. This appeal is dismissed as withdrawn. What is the court fee of it? $30,000 in view of withdrawal of this appeal. The entire court fee may be refunded in favor. Have you filed the bank statement of him for refund? The entire court fee may be refunded. It shall be refunded to the appellant, to his bank account on the appellant furnishing the bank account, IFSC code, and other required details. Registry shall transmit the amount to his account on proper verification. As per 6C of the Karnataka Court Fees and Suit Valuation Act, as the matter is disposed of at the preliminary stage itself. Yes, refund. You give the affidavit to the registry, give his bank account, IFSC code, all other details, branch, everything.
Question number 34, question
Plaintiff's appeal against? You're ready, madam? Yes, where you want to? Suit is filed for what?
What happened was, we the fact that I became a donor member of the family club in the year 1995. Thereafter, in 2002, I tried to relocate Canada from Guru. My connection that I informed the Canada that I will be relocating and sent them my forwarding address. And I shifted Canada from Guru. Now, in 2013-14, I sent them a request saying, "I'm ready for the facility of the club. Kindly organize them." About October 2014. And they say, "No, your name does not appear in the list of members. You cannot give you facility." I say, "Okay, on the phone, there's nothing much more that I can do." Next year, in 2015, I relocate back to India. Which is when I go to the club myself and verify why they refuse detective services. At this point, I'm informed that in the year 2011-12, certain luxury taxes have been imposed by the state on the club, which they passed on to their members. Therefore, every year I was supposed to pay some 600 rupees as luxury tax. But I have not paid this amount, they have cut off my name from the law. Now, I find the suit challenging, I find the suit declaration that I am still a member and interpreting the state that from preventing me from using the facilities at the club. My contention is essentially one that I have never served any notice for this statement at all. Second, because I have never served any notice of termination, even if the payment was. Thirdly, I have attempted to make the payment after I came back to India. I sent him a notice around the same I am ready to pay my entire please revise my membership because there was nothing, no part of mine in non-payment. And fourthly, that payment was not due in the first place as per the rules of their own bylaws. Now, the cause of action that I have is in the year 2015 when I was denied service. When I came back, I wanted to use the facility. They denied me the facility that is where my father had the body. At the worst case in 2014, when my services from the friend of mine was denied. The trial court finding a normal right from page 21 onward. Specifically, in this case, related to the donor member of Catholic Club, paragraph number 7.
Yes, yes.
This is registered under the lack of certain cases and the club is promoted and fostered right and visual right and visual right and all Catholics. It promotes also the last sentence, the types of membership include various types of membership for each type of membership. Separate charging privileges are provided. Because they are ready for it, and they don't have we are 1987. At that time, they paid considered to be very high part of that. And what is paid on the address of one to the club, that it does not pay any amount whatsoever to the club at any point of time, and they use facilities from the club free of cost. But during the year 2002, they can move from Bangalore to Calgary, Canada, with Canadian. They can typically travel to Bangalore and work with the club. Before leaving Bangalore, they can notify different number one that you go to Canada and offer visits and offer. They can shift to Canada and remain outside India and shift abroad from the only. Again, return to India to month of February 2015. Patent called different number one to make a reservation for a room which is located in Africa for one of the state of the phone call. Patent was informed that one of the office now is not seeing the role of available in the state. Then they need to move forward. Data could not result in distributed over. All officers are also informed to reach to plan of again, Thereafter, he approached first and learned that he didn't receive from Mr. Member, probably due to the fact that he has not paid luxury taxes to past member. Although they will inform the side office, inform about payment of tax, officer informed him that nothing to be done at this stage. And later could not use the facility to further the data. Later thus came to believe it was under the assumption and was terminated from members. Next, para 8, they have heard of certain for the memorandum of proposal rules of the next page 25. 7.5 is what is interest rate the government might go. 7.5 says the managing committee may, however, at its discretion, restore the member to the role on payment of such fine and real-time charges and arrears of subscription and or plans to be decided by the bank, provided following conditions are satisfied. The management committee is convinced that there was something to be for non-payment of because for the admission is made within the year of the date and information are offered. The rest of the bylaws are not.
When were you stuck up?
According to them, I stuck up on 1/1/2012. But this came to my knowledge only 2015. Because striking off is not per se by way of a termination notice or by sending me any correspondence. This is my deletion from the law.
Yes.
Paragraph number 9 is what of page 26. In light of the aforesaid rules of capital law, defendant argued the truth of the genetic bars by limitation and this declared by the under 7.11 as seen from notice which is produced in document number R2 dated 28 background address of Bangalore of the bank and document number R3 reminder notice of address dated background address dated 12/11 were referred unclaimed. Under such circumstances, by invoking Rule 7 of Memorandum of Association and its sub-rules, plaintiff has been removed from membership of that member. Being appealed by order of that member, plaintiff preferred his suit for declaration and for proposal.
So did you inform the club that you are going to Canada?
My stance that I informed.
Huh?
My stance is completely that I informed them and given them the property.
Your stand has been. No.
I did not.
So that is clearly a statement.
Prior to this one out of letter, I have informed them about it. It is based on their records that I have done to.
Okay.
Schedule 58, Article 58 of Limitation Act reads as follows. To obtain any other regulation, you have the right to sue for control. But as per notice, right to sue approved 3 years from 1st January 2012. Now, the notices are dated 19/9 and 12/11/2011. Correct, I have put that as per that notice, the 3 years are from 1st January 2012. But sue was filed on 26/11/2015, which is more than 3 years. That is also barred by law. No limitation bars the remedy. Parties to suit have discretion to readmit plaintiff as owner under Rule 7.5A and B of the Memorandum of Association. Order then is that the suit is dismissed. We also see on page 28. There is one observation here that defendant has got discretion to readmit the plaintiff under Rule 7.5A and B of the Memorandum of Association. This also has not been done. I have been informed that although we made a request, they said, no, he is not right. That will come within 1 year. If you have not done it, you will not afford, please go ahead. Now, if I will take a moment to my brain. Okay. As I informed about the issue order does not refer to state government at all. It only refers to the notice that has been already sent by the response, which admittedly have written unclaimed. Because admittedly I was not in the country at that point of time. But paperwork is not defined, but trial court records are all.
Where is the question of paperwork when there is no evidence? Why do you need paperwork?
Because the trial court records are not in the order.
Huh? Paperwork is dispensed at your request. All right. What do you want to read? Yes. Read that. All that you don't have to repeat, you already read that.
Already am I saying that the alleged termination to not be done? I'm also saying that the very basis of that the luxury tax of 600 rupees per year is not binding on it. It's not valid as per their rule. On page paragraph 50, page 5. I said even if one were to assume that the tax has been terminated, it's probably assumed that the termination is legally contrary to the rule of bylaws of first America. Firstly, no notice of dwelling was appointed to take before the alleged tax is reversed. And that's the action of the first person rather than illegal. Secondly, no notice of circular was issued to the first America. All members who benefited based on per year towards paying the luxury tax. Thirdly, luxury tax benefit the government of first America are not like members of the state. To be illegal of first America to ask primarily to pay tax on the member. Fourthly, the state being a donor member is exempted from payment of all any fee charges and living payments as per rule 4.1 of the state rule. Donor members are not required to pay. As per rule 1.6, any statutory living will be imposed on the government of first America. So we paid the resources collected from by government members in the like manner. It's very clear that the side of the donor member is not liable for the government living that they are exempted from payment of subscription as of rule 4.1. And they do not fall under concerned member as compared to the others. I also stated how there is a non-utilization fee for persons who bylaw 16 million. Purpose of the rule 7.9 provides for non-utilization fee chargeable on members. However, such a fee is also not charged for donor member. They have never been charged for payment, even when the payment was abroad. So for 10 years, I have not paid them anything in my charge at that. Now, I will come to the notices that they have said. But my was actually found paragraph 90. Page 7, paragraph 90. The first action for filing issues around 1996 to the plaintiff became a donor member of the first America. 2014, the plaintiff was informed and not took a loan from Karnataka. So in March 2015, the request was denied by the club. On 14th September 2015, the plaintiff got issued a loan. He noticed on 15th May 2015, the plaintiff again wrote a letter to the defendant. And on all such cases, the following of the plaintiff was legally restricted. Now, my case was referred very simple. This is I have been abroad for 10 years. I have not received any communication from kind of work, let alone any payment reward, let alone any termination notice. I come back and they inform me one day that no, you have been terminated from the work. I say I am willing to pay whatever reward I have committed. It is 600 rupees per year is not a big amount. The amount they are taking earlier itself is not a probability. So I send them a check along with the letter to please accept this and because I was not for so long, forgive the lapse in the time. Let me continue my membership because I paid a substantial chunk of money when I became a donor member. Now, if I show the rule document number 2, which is not in the plate, is the rules of the.
What was your membership number then?
My membership number was initially 1551, was initially 1581, and subsequently it was renamed to F09.
09. No, 15. 151.
1581. My initial membership.
So you are the donor member, means you are the one who started the club.
No. So the categories of membership probably are page 18.
You became a member in 96.
96 started in 1948. I'm not saying that I'm a founder member. I do claim that I've contributed to their growth by way of giving it services, by way of being involved in the community and things like that. I do claim that I've been involved in the community.
Yes, what do you want to rely on?
Page 18
Of?
the place document. Regulation document number 2 along with the place. Document number 3 along with the place.
What is that document? So page 18 of the appeal memo. That will change now. That will not, that will change because of the trial court. What are you trying to rely?
Page 18 of the trial court.
Now, what is that page 18?
Page, document number 3 starts from page 14, that is the rules of the
That will go. That pagination will change. So you are relying on some rules. Which rule? Which rule you want? Which rule? Which rule?
That there are 20 categories of members, of which the topmost category is the donor member. It's what I call. There is donor member, then there is lifetime member, then there is ordinary member, senior dependent member, visitor member, honorary member, associate member, choice. So at the end of the room are also the fees structure for each of the different types of members. So what is the big difference there is between the donor member and the other member? The whole purpose of taking the donor membership was the assumption that I will never have to pay anything again. No monthly subscription, no other charges, no login charges.
What is the ground of this IA Order 7 Rule 11 file?
Limitation and impact of
So basically the attack is on the ground of limitation.
On these, all the members in the club, I say, but the difference they will on these grounds.
It's a your association is registered under the Societies Registration Act.
Association of person.
Huh?
It is not registered, it's not registered, it's just an association of person.
It can't be without registration, madam.
It's like value of a vote. So these are, registered in the society. Very few not registered as class of society. It is operated as an association. In which case, the want to do the association was classified necessary application. Either they will take a publication, it might be all members, making them that since have been cited, etc. Or giving business.
We have a bylaw.
Yes, sir.
How can you not be registered?
All these are
No, it shows that it is a registered under the society's registration. That is defined by as per his state. So you are not a registered association. But any association or club will have to be registered. And where is the statutory sanctity, or how are you governed by for the purpose of your account?
But otherwise, when it comes to suing or being sued, necessary application is there. Each time. The end of the day, the managing committee, etc., only represents the entire club. Each member will have to be served notice. And
But you are also serving liquor. Correct. Under the Excise Act, you will be given permission. So what have you described yourself as? Correct. Association of persons will have to also get registered. All right, we'll come to that. Sikta? All right. So you want to read memorandum of rules and association rules? No, what are the only ground you are challenging is that Order 7, Rule 11 has not been considered on the basis of your plaint governments. Because you have been arguing only on the merits rather than coming to the. No, but why do you want to corner this man who's aged 60 years? He's a man who paid at that time 55,000. Probably now it must be 5 to 10 lakhs. Why don't you consider check with your people and ask him to pay some money and whatever arrears he is liable to pay. I think it is more of an ego than anything else in it. Because Catholic is a Christian coming from the minority and he was out of the country, notices served, so some local address here. He may not be aware and I don't think he would have not paid that amount of.
Whatever it is, no action has been taken by me from 2012 to 2015. So on the face of it.
But your written statement and documents cannot be considered for rejection of claim. So, Mr. Counsel, what's your name? Kashyap. You're Chetan. So why don't you sit with Madam and impress upon the defendants to agree for some terms? Madam, will you be able to persuade? So I will just adjourn this matter without referring, because if it goes back to trial court again, it will go on. The very purpose of him using, he's 60 years and odd. What's his age now? End of the day, for you have described yourself as 60 years even in 2007. See, for an old, no, I will not say old, for an aged man, club is the only solace. To live alone, I don't know whether he has got family and others, because now he's come from Canada. So maybe his family is there. He'll be left with nothing else to just go spend some quality time there. So if that is also not there, probably it may be beyond his reach now to get fresh club membership. So just consider these on humanitarian grounds. All right. Third Learned Counsel Chetan, on behalf of appellant and the Learned Counsel Srimati Nidhi Shri BV for Kivator respondent number 1. After arguing the matter for some time, both the learned counsel for the appellant submits that if an amicable settlement could be arrived at and he would be willing to pay any arrears of amount that is due towards the respondent club if he is taken back as a member of the club, to which proposal learned counsel for the respondent seeks some time to inquire and with her clients whether such a proposal could be explored, keeping the submission of learned counsel for both the parties. I deem it appropriate in the facts and circumstances of the case to release this matter after 2 weeks to facilitate both the parties to explore possibility of an amicable settlement. We'll release after 2 weeks. Just after 2 weeks. Third, make your effort If possible, well and good, otherwise we'll decide on this. CH Rao. Ramakrishna. 2017 injunction suit. Who are you? Plaintiff or defendant? File illa. Nodima, plaintiff or defendant? Plaintiff suit dismissed. Injunction. Injunction suit.
Several proofs. Next week.
Request of learned counsel for the appellant released next week. Yes, Mr. Naveed. Hari Prasad, this matter came up earlier? Okay. Yes, Hari Prasad, suit for possession.
Defendant as his grant a land, 2 acres of land. And that 2 acres of land subsequently alienated by the allotted person. The possession was restored to the upper class of the order. And the minor, he is in possession. He
Yaro, who's in possession? You are the defendant. Yes.
Possession and also 93. That will be that case is my lord. What happened? After 2009, the order was in 2009. Was passed by the Assistant Deputy Commissioner regarding the cancellation of the regarding the safety cancellation of safety etc. Again
of the plaintiff.
Plaintiff. And again that the secretary to pass the order against that it must try before the start of the work. And in 2011, it was allowed. And in 2000, writ appeal filed. That writ appeal also developed. Submission is.
What is allowed? What is allowed?
That's in the special counsel order.
Is confirmed.
Property has been alienated. That because the period is over.
Who filed the writ petition?
Filed the writ petition from the others. Why the filing the requisition of land? 2011 this is filed. Yet in that 2009, this process will by the defendant. 2011, same requisition. See, before this started court, she stated that I am in possession of the food property and obtained.
Suit is only for possession. That is admitting your possession. Ilri, Hari Prasad, he has filed a suit for possession against you in 2011. That means you're in possession. He's seeking possession from you. Where is the question of dispute of your possession?
The petition, she has stated that the plaintiff is in possession of the property.
When is the writ petition? Yeah, when is which year?
2011, after filing the suit. After filing the suit.
After filing the suit. And took an order of? Stay of what?
They have the order of the special deputy.
All right.
And also sought for not to dispossess.
Both
they are the fraud.
So contradictory.
Now you are right. I didn't see the order page number 112.
Our
So last is the privacy. The question is, in period number, issue framework, in the judgment, page number 193, 192.
of the paper book. Yeah? Correct. Yes, sir.
193. 192. Whether the court has no judicial credits as filed on the SCST provision of land act, it is not clear. Whether when to defendant disposes of them in January 2009 comes to property. And on this point, I have not disposed in 2009. I have been posted on the property in 2003. Because that will show many records, what I produced before that work. Here is what was left. Now, the question is, when I am not disposed in 2009, I am the question of CPD. Question. It is true. That I will make out from the records.
No, the issue number 2 is whether plaintiffs prove that the defendants dispossessed them in January 2009 from the suit property. This suit is filed in 2011. So after dispossessing the plaintiff, you have got into the property. Is their case? Now they are seeking to, now asking you to.
But the she admits that she is in person in the recruits.
All right.
And in the table also she admits she is in person.
So that contradiction you want to bring. So when is that when is that writ petition? ಇಲ್ಲ ಸೂಟ್ ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ ಅದು
Number 20083.
20083
2011.
page
Page 81.
So very same persons who are plaintiffs and petitioners. Yes. All right.
Number 5 is the author of the order not page number 88. It is the order. Technically, the order of the but they are not the sale is not confirmed. As against this, they find it appeal. Number 1734 2011. This is a page number 99.
All right. Confirming the order of the writ petition.
Oh, I will take your lordship to the class examination of the PW1. In page number 46. I will find this too. On first term, we do that.
Cross-examination of PW1.
I will find this too on first term, it is true to collect that. Special Deputy Commissioner passes the order on progress for the suit property safety act. To say that, and the lifetime of my husband for OS number 360 for the sleep of permanent injunction. After the death, I claim for the record and the suit between our
Against whom?
Suit number OS 33 66 March 2002.
Against whom?
I against the defendant.
Very same defendant. This was filed by the during the lifetime of her husband.
Defendant initiated proceeding under PPCL Act before the concerned authority. It referred petition violating the order passed by the special deputy commissioner. The certified copy of the said this petition is not as legal. I have given instruction to draft the petition to my lawyer. It is due to say that in the said petition, I have said that I am in possession of movable property as of 6. Yes. This due to say that petition can be allowed on 11/7/2011 and the order of the special deputy commissioner was is due to say that the defendant is not requested against the said charge. This would say that the said petition is given for the district. I have not stated in my friend the intention of taking the institution and further proceeding. This would say that no evidence of other proceedings related to the institution and further. This would say that proceedings initiated by the defendant the PPCL Act before the Assistant Commissioner. It was for program came to the district. The order the defendant is possessed me of this property. The month of January 2018, 21st January. We do not know when I have taken 90,000 for the admit each year there any cost. Then my God, after class examination, the page number 50. This group to suggest that at the time of filing a picture, who will add this?
Yes, sorry. Is true to suggest.
Other process. It used to suggest that the time of filing a restriction number, 28, 2008, the different was in for the
She admits.
that the time of filing the suit, the defendant was in possession of the suit property. Now I am sure, but the judgment and decree also, the same is not by decree. It's true that the defendant filing written statement, he says true, stating that eating was another property. Who needs time eating was? We have had one taken this during the purchase.
That suit, OS number 3366, was filed by the plaintiff for bare injunction. ಏನಾಯ್ತು ಅದು? Dismiss ಆಯ್ತಾ? For what? In the written statement. Then how it was decreed?
Since it is pending, that the
ETC.
cannot be proceeded, it cannot be proceeded. But that was overruled and proceeded with that can be accommodated. We had one prejudice from the purchasing of the property. We do that on 29/4/1930. Two property was granted to a fee. Accordingly, mutation is accepted in the year 1940. With the grandfather of the defendants. It is not to say that Munda is not able to cover purchaser, but I division and it is not to say that name of Munda, even in the account. It is not to say that name of the defendants attend the revenue account books for the year 2004. Not to say that it is not converted. That is not to say that under how to do Karnataka, so it is not go to there. There is no source of they not go to that. There is no level of that. So I will not go to the Kaka standing in the name of all the agents. Not go to the Kaka standing in the name of all the agents. Not go to say that I will not go to the other document. So the question of my vendor. Not go to say that created the process of at the time of filing of the proceedings and you have not go to there also we got GT evidence process. Then I had on the Hanuman we have to his exam and his cross examination. Take number. Take number 55.
Yes.
Now, given instruction to drop my evidence and drop out to notice, I do not know who was present and not who was present. It is not to suggest that not know the content of the I have not received any summons from the court. Also, referred discussion against the order asked by the section commission. We detail that clear to of the order. Maybe the current picture in the set. We do not know that the criteria to set WPS certificate that this is not at least to that I am not deciding near the future problem. That is having said near this problem. After the problem from take a job, look for the system to the then I came to know year 2011 and we graduated for this current discussion in 2011. Is not to suggest that different are procedural to property. Is not to suggest that different are procedural to property. It is where that play to be possible. Is not to suggest that they are not they want remember the date and month of the disposal. Is to that different is in relations of the property. I do not remember the date when the equivalent.
You are having a ration shop there
It's running a ration shop.
from 12 years.
From the budget is equivalent of the portion for the Milligan and system of equivalent not to say survey is converted land and all this. Then my lab, another witness by name Modira. Is also page number 60. Class examination. Any evidence? Any evidence? Have you given how many evidence? All this after 4 lines. It's true. And I am also mentioning I do challenged by this special DC. The present writing is also a prediction of the it proved that the writing was submitted with the ability that CE in possession of the two federal property as on the date of bankruptcy. That the entity is in possession of the properties is made. I do not know that when the plaintiff was dispossessed of the two property in the year 2009. I know that when the cash value is in the year 2013. He was present when she was disposed from the property in the year 2000. I do not remember the year when the defendant is in possession of this property. You can say it is in 12 years. It is not to say that I am disposing partly in the when it was disposed of the property in the year 2009. It is not to suggest that different are in person of the property for the year 19. Not to suggest the properties of pending in the was right. Now, see the trade is breaking. That two land is not converted as a land. Not to suggest that because of property and instead of entry, not to suggest that it will not be. Now, in support of my contention, my heart, the practice of railway take exhibit
Page.
To set the order, this is the order of the assistant commissioner. Yes, you are not in the guidance. Pratapan in अन्य विशेष जिला न्यायालयದ ಆದೇಶ ANC BI 32/2003 ದಿನಾಂಕ 10/10/2004 ಉತ್ತರ ಯಶವಂತಪುರ ಹೋಬಳಿ ಆಸನಡಿ ಗ್ರಾಮದ ಆರೋಗ್ಯಕ್ಕೆ ಜಮೀನು ಈ ತಾಲೂಕಾ ಆದೇಶ CSS ದಿನಾಂಕ 2/6/2008 ಮರುಚುನಾವಣೆಗೆ ಆದೇಶ ಮಾಡಿರುವ ಮೇರೆಗೆ ಪ್ರಕರಣ ವಿಚಾರಣೆ ಪ್ರಾರಂಭಿಸಿದೆ. Lordship may kindly see 2002-2003, the proceedings taken before the assistant commissioner by filing an application by the recorder. And in that manner, the order passed, the application of the deponent allowed, and he is in putting portion of the property. That would get the lordship get a document that produce the exhibit.
Now, what is the Adesha in this? In exhibit P9D90.
Adesha, in order was merged in the division by order. But when yours order was certified, not by same was confirmed in my favor. So, in fact,
Stating that the PTCL Act will not apply.
Delay in
I'm not disputing. Yes, I know order and not. I will call the procedure regarding the person. Finding is the finding is the different. This was implemented in 2009. I'm only on that point.
That is contradictory.
Regarding that aspect, I'm going from the document.
Yes.
So last time I say exhibit 19. That in that first document, it is shown the earlier history.
Yes.
Earlier transaction. Your lordship can see, as for earlier transaction, the assistant commissioner, even the possessor of property, regarding that aspect, I have produced the document and mark that is available in exhibit. Exhibit P12 on 2 So now, as per the Act, Prohibition Act, the defendant is putting portion, otherwise what is not implemented. Yeah, my lord.
What is D12? D12, you know?
The mutation. After passing the first order, the assistant commissioner putting the portion of the property with the
Defendant.
One is to 2 acres of land.
the order of the order of
Doing the document. Second issue. Second issue, I am on the point. I will canvass regarding this. I learned as per the Act, they have to implement it and putting portion of the dependents property. That's not the order. As per the first order, they have put into portion of the property in the accordance with the as stated in the Prohibition of Land Act. And after putting in portion, mutation made, that is in 2000. This clearly shows that the dependent putting portion of the property in 2003. Revenue record. User afterwards they are in possession of the property till today.
So where does it show here that this is a mutation?
Mutation.
So So where does it show that you are put in possession?
KST number FT, so that on the second column.
Ah.
Here. Okay, KST number.
Yes. 6/1/2003.
Yes.
Yes.
So my attention, my lord. Well,
Yes.
then, when this being the case, whether plaintiff owing a imaginary cause of action might be sued for the
Possession.
purpose of this case. And regarding that aspect, my lord, I am relying upon judgments of the Supreme Court. We have not, my lord, the second case, 2393 law. A cause of action.
Where are you reading? Cause of action.
Cause of action means every fact it travels, it will be necessary for the plaintiff to do the order to support his right to a judgment of the court. In other words, it is a bundle of fact which is taken with the law applicable to them. The plaintiff a right to lead against the defendant. It must include some act done by the defendant. If the offense in the absence of such and
Act, such an act, no cause of action.
is not limited to the actual implement of the right to law, but include all the material facts or to this. Here you are not looking at anything. Paragraph 27 of the judgment. Very clear.
Yes. Same thing as with retreat. Yes, cause of action.
Action.
ಅದನ್ನೇ ಹೇಳಿದ್ದಾರೆ. You can skip.
The action is not equal. ಇಲ್ಲಿ 2009 ಡಿಸ್ಪೋಸ್ ಆಗಲಿಲ್ಲ. imaginary cause of action. For that purpose, I am relating.
All right.
Then another judgment of the Supreme Court. The paragraph 9, 200.
Yes.
Paragraph 9. Right. 200.
Yes, yes.
Right. Cause of action. When every fact which each travels, it would be necessarily for the plaintiff to prove in order to support its right to the judgment of the court. In other words, a bundle of facts which is necessary for the plaintiff to prove in order to succeed in generic and wise then as section 20 of the Procedural Code. Cause of action means every fact it is necessary to establish support a right to obtain judgment. Then it is settled law that cause of action. And these are bundles of facts. The cause of action, the legal inquiry of witness in the court of law. In other words, it's a bundle of facts which is taken to the law to them. The plaintiff, a right to claim is against the defendant. It must include some act done by the defendant. In the absence of such an act, no cause of action could possibly be accused or there is based upon earlier judgment I have found. Then the expression cause of action, equal and judicial support mean the restricted sense. Cause of action means the circumstances following the infraction of the right or the immediate system of the gas. Wider sense means that necessary continuation for the maintenance of the suit, including not only the infraction of the rights, but also the infraction according to the right itself. Comparatively, as noted above, the expression means every fact which is necessary for the plaintiff to prove is covered in order to support his right to the judgment of the court. Every fact which is necessary to be proved as distinguished from every piece of evidence which is necessary to prove that corporation is cause of action. The expression cause of action as something sometimes we trying to convey the idea of factors.
All right. So they have discussed cause of action, which is a bundle of facts.
Now, it's higher court. For this contention, my contention, not given single findings. Only said, by they have found the civil suit, thereby they have obtained the injunction. And hence I am presenting that there is portion. That is the contention. Without considering my documents and right there says, since injunction it amounts to their in portion and they have disposed of it. And all these contentions, logic, admission in the cross examination, all these things, it was better. And directly transaction.
Yes.
And so far as minor people they have constructed the shed to run the nation report. And that is only the livelihood for the entire family. And it is not constructed by India group and all these things. They are not cemented.
It's a shed.
Only shed. And the entire court finding, I have not obtained the license, I have not obtained the license, I plan from the competent authority and all this. That is the CCT disabled is not required. It's not a permanent construction. Then my lord, finding is, I have, even though I have produced my wife name license is standing, license before, license is standing. And electricity, all these things are produced from the beginning. And all these documents are not considered by the higher court regarding this aspect. That is my submission.
All right. What is your right on the suit property you are claiming? What is your right on the suit property you are claiming?
Regarding the right to my land, as for the Supreme Court decision and all this, I have not disputed. The owner, I have not disputed. But regarding the person.
So you are admitting that you are not having any right now to stay in the property. But you are arguing that his cause of action is imaginary, contradicting to his own writ petition. There is no question of dispossession in 2009. You have been staying there from 2002. But you are now bound by that order of the writ petition court and the writ appeal court.
I am not disputing that. That's why my only case is on the letter.
How much time you want?
And like I have 2 years and you will
Yeah, Naveed bhai. He is not disputing. No, he is not disputing.
Let him pay me without doing whatever the rent was. I have no objection. Let him be continued for another 1 year. Pay me in advance, pay me the rent for the another 1 year. And from the beginning for 2009. But let him pay and let him enjoy for another 1 year. They often leave it open.
No, there is no order with regard to payment by the trial court.
That's correcting law. Now if he wants to continue.
Correct. Now
Now it wants to continue.
damages you had not claimed.
That's which profit we have to identify straight.
Correct, sir. So now,
Since it is a compromise, I'm willing to give him the time. Let him pay the rent.
what is the rent?
So we know better what is going on in the property law. But the minimum rent clause.
Find out.
I'm not exorbitant on that.
Now, Mr. Hari Prasad, the fact of his ownership is set at rest
Yes.
by the writ petition. No dispute. You are not disputing. You are only on the point of initiation of an imaginary cause of action. The fact remains that thereafter the suit, he says that you are in possession, you have to be evicted for possession based on his title. Now, if you see all that imaginary cause of action, we'll have to take a larger perspective as to whether it should be remanded back to for fresh trial or what has to be considered. Now, in view of the fact that you are admitting that you are in possession from long process of time and to be continued, just check with your client how much time he wants, what is the rent he will pay as per the market rate. Mr. Naveed will check with his client. If he is agreeable, then you can enter into some agreement. Your interest would be to continue for some time so that you can make some other place accommodation to shift.
Very difficult is not. I mean, because having not two daughters, one daughter.
All right, you will get money. He will give you some rent, reasonable amount. You find out. Really? Day after tomorrow? Yavattakana? Hey, our timing bakery. Let us give some time for him to call his client. You also call him. 13th alive, 16th akana. 16th tariq. You take even on that day, if you are unable to read, you can still have a preliminary discussion. ನಿಮ್ಮ colleague ಇರ್ತಾರಲ್ರಿ.
We were both traveling. 15th.
We'll have it on 19th. Now let us give him some time. Now he has made it clear.
Yes.
He is not disputing your title, sir. Him title dispute ಮಾಡ್ತಿಲ್ಲ ಅವರು. He is only now seeking. You are arguing on legalities of cause of action being imaginary. Heard learned counsel Sri Hari Prasad, Y. Hari Prasad for the appellant, and learned counsel Sri Naveed Ahmed for respondent number 1 and 3. Who's appearing for 2? Dead, huh?
Please no more.
So R1 and 3 are LRs of all. Both the learned counsel submit that they would explore the possibility of an amicable settlement. Hence, they seek some short accommodation. Relist this matter on 19th.
Let my learned friend communicate in
You communicate on 16th.
At least on 19th, we can expect some others.
Hari Prasad, you inform him either on 15 or 16 over phone. Relist this matter on 19th. Yes. Yes. Relist this matter on 19th to facilitate the parties to explore the possibility of settlement, if any. Lord, you be a little generous because I think your client is also requiring money. He also needs some time. It's just an adjustment.
To the lordships kindly.
Yes, sir.
Serial number 40 wrote that I pray for a 2 weeks time. The reason, my lord, is that the another MFA is filed by my client because it pertains to an arbitration class.
Which number?
40, my lord, the last.
What do you want, sir?
I pray for a 2 weeks time, my lord. By the time I will move the MFA, that it will have I will intimate that the Papa number, Geeta Devi Papa.
All right, she's not here. Geeta Devi.
I will intimate.
When do you want?
That after 2 weeks.
At request of counsel for the appellant relist after 2 weeks. He submits the lead. He will inform learned counsel appearing for respondents 1 to 10. Or inform ಮಾಡ್ಬೇಕು.
I will inform.
Yes.
I appear for the respondent, my lord.
Yes, sir.
My lord, this is a matter relating to the declaration and wherein it is a defendant's appeal, my lord.
They ready? Yaru? You are ready, Mr. Ramesh?
I am ready, my lord.
Or in a time kelta idare is not well ante.
Okay, a week's accommodation may be granted, my lord.
At request of counsel for appellant, a week's time is granted as he is keeping unwell. Relist this matter after a week. The counsel Sri Ramesh Ananthan is present through video conference for conferencing for the respondent.
Much obliged.
Mr. Mugidan. Tell him to get ready and argue next date, sir. Have a passover, madam.
ಹೌದು ಹೌದು ಹೌದು